হ্যাঁ হ্যাঁ। Milord, I'm appearing for the opposite party number
I
one.
appear for the petitioner, my lord. This civil revision matter assigned to lordship, my lord.
That this matter was substantially heard by your lordship. My lord, kindly keeps it any day after 27th, subject to your lordship's convenience.
After 23rd.
27th.
After
27th.
27th, my lord. But only difficulty is, my lord, the interim order is till 31st of July.
May I say this, Milord? Let it be fixed on 28th or 29th. If this matter could be disposed of on that day, very well. Otherwise, my lord can extend it.
Maybe I may have forgotten everything. I'll have to hear again.
Yes.
Lord, here, Milord, what happened, Milord? My application under Order 1, Rule 10, Milord, for striking out the name of Milord, one of the plaintiff, one of the defendant, the defendant number 2, Milord, has been rejected. Milord, defendant number, Milord, they have filed a suit for recovery of money against a Milord farm. Milord, the defendant, money against a farm. Now, Milord, defendant number 2 is, Milord, not even a partner of the farm. Milord, whatever is there is defendant number 1.
Firm.
Yes. No connection with that. Milord, on that ground, Milord, defendant number 2 filed the application. Milord, that has been rejected, saying that it cannot be decided without trial.
This matter has
Court, my lord, I have instruction to appear, my lord, on behalf of the plaintiff opposite party.
And I'm giving the copy.
Come back,
Whenever he comes back.
लिखे नहीं? This matter has been assigned to the
No,
bench by the honorable the activity
এইটা হচ্ছে
7
here, my lord had already heard this revisional application. There was, my lord, direction for service. My lord, kindly see, my lord, two orders. The 16th April and the 20th March. My lord, pursuant to the 16th April order, my lord, we have also again served the non-appearing opposite parties.
The learned advocate in the court below has been served.
Yes, my lord, I have handed over, my lord. Lordship had passed the order on 16th. We have served it on 19th and also by speed post.
This one.
But they are, my lord, on the, my lord, same family members, my lord, the same advocate can obtain vakalatnama.
Very well. But you intimate the learned advocate who appeared here.
Very well.
I'll keep it.
My lord, two things, my lord. There are two applications which has been filed. One, my lord, can one substitution application for
Somebody has died.
somebody has died within time, my lord, and second, my lord, interim order has expired. Can two, my lord, I
Impose that. But substitution has to be done first. Which one is this?
can one
Can one of 2026.
particulars are given in
Is an
para My suit. The court has said that it will proposed amendment, if allowed, will change the nature and character of the suit, and the defendant will be highly prejudiced.
What did you want to
My
do?
lord, if your lordship would kind enough to come to page 38. Kindly see the schedule of amendment প্রস্তাবিত সংশোধনের বিষয়, which is at page 39. My lord, kindly see, my lord, virtually, my lord, correction of errors. My lord, it has been recorded as 100 rupees. The valuation would be, my lord, 10 lakhs and more 10 lakh rupees. My lord, these are the. But what played in the mind of the learned trial judge, my lord, he thought, my lord, since 10 lakhs, his jurisdiction will be curtailed and it will be go before the, my lord, senior division. Perhaps that played within his mind. All, my lord, these. Then, my lord, paragraph 3, kindly see, বাদীপক্ষ প্রার্থিত 10 লাখ টাকার উপর কোর্ট ফি দিতেও প্রস্তুত আছেন, my lord. These are, my lord, my formal. And, my lord,
But there is a judgment, Mr. Bhattacharya.
but that stage has to first come. I know.
That such amendment will not be allowed by the court if it is taking the jurisdiction out
My
of
lord,
it.
Justice Girish Gupta's judgment is, if it is allowed, court will, my lord, transfer it to the, my lord.
There is an earlier judgment also. There is an earlier judgment also, just the reverse of it, saying that the court will be knocked off the jurisdiction. If the court does not have jurisdiction to receive it, it will not have the jurisdiction to
But
amend.
he doesn't say that. He says, my lord, nature and character of the suit will be changed. I could have understood, my lord, he said.
Served and filed. This revisional application is directed against an order dated February 9, 2026, passed by the learned civil judge within bracket junior division, comma, second court, comma, Diamond Harbour, comma, South 24. No, you wanted extension of time.
Yes, to deposit the 7-2. This is not 7-1C. This is 7-2 after adjudication.
After adjudication, you will get 2 months.
2 months, once for 2 months.
Yes, But if you pray for extension after 2 months,
No, that is not there in the statute.
no, but that has to be, then this becomes meaningless. If you are getting an extension for 2 months and you are praying for extension after 1 year,
Mm.
how will that serve
No,
the
not
purpose?
not after 1 year, my lord. The petitioner, the defendant's eldest daughter, my lord, is in USA. My lord, that is the, my lord, explanation
But
given.
then you have to
She-
come within the zone.
True, true.
After the expiry of the time for which extension is supposed to be granted to you, you allow that time to expire and then you seek extension. That can't be. Because the purpose is frustrated. The purpose is that once a date is fixed, within 2 months thereafter you have to pay. Now you come at the 3rd month. What will be the purpose of extension?
No, that, my lord, extension, my lord, after, my lord, we file, my lord.
Be within 2 months, Mr. Bhattacharya, because how will you interpret this section then? It doesn't make sense.
Not the, it was
Have to read
disposed.
it meaningfully.
The statute, my lord, does not, my lord.
That is how you will have to read the statute. Otherwise, what is the purpose of extension, Mr. Bhattacharya?
It says, provided that having regard to the circumstances of the case, an extension of time may be granted by the once and the period of such
Now, let us
extension shall
understand
not.
this way, Mr. Bhatt. I'm putting it simply. You are getting an extension of 2 months. Now, say I come after 3 months. The court will grant me extension for 2 months. Will I be able to deposit within 2 months? I'll be depositing in the 3rd month, which the court does not have power to extend. So, in any case, it goes beyond the time. Let us see it this way.
No, that is, my lord, 7(1)(c). But an extension,
In this extension, when the court decides and grants you time to deposit the amount determined under 7(2), the
Yes.
court says you will deposit it, say, by 5th of January. Now you are to deposit by 5th of January. If you fail, it goes to 5th of March, 5th of April. Now you make an application on 5th of May. If you make an application on 5th of May, the utmost that the learned trial judge can do is to extend it till 5th of April.
The 5th of April.
On
Yes.
5th of May, if he extends it till 5th of April, that doesn't serve your purpose because by that time you have crossed the deadline. So you have to come within that 2 months only. Otherwise, it doesn't make sense.
See, my lord, if your lordship kindly comes to page 36. 36. My lord, this is the order of 7(2).
Yes. When was this passed?
The 2nd of April 2024.
And when did you? When was your?
Page 39. Page 39. 3rd June 2024. My lord, at the top left-hand side.
Page 39.
At the top, piled on 3rd June 2024.
You know, when was the time?
Time is, my lord, within 1 month from the date of passing of this order.
So this was in 2024 April. So was to be put in by May 2024, and you filed your application on June 2024.
3rd June 2024.
So May.
Huh? No,
May to
Calcutta
June,
also
June to July. So you still had 1 month's time.
1 month's time, my lord.
Time you had. So you are within zone.
That is, my lord.
Right.
That is, my lord. A court, my lord, simply says you have not complied, not complied. My lord, court doesn't say go into that aspect of.
This revisional application is directed against order dated February 13, 2020.
My application, my lord. My lord, I've been a tenant, my lord. I filed a suit, my lord, and I've obtained an order of injunction, my lord, not to dispossess me, my lord, till, my lord, the end of the suit. My lord, now, my lord, initially, my lord, had come up before this court and also before the trial court, my lord. I was not being able to access, my lord, my meter room, electricity room, and, my lord, water for my water. So, my lord, here this honorable court, my lord, had been, my lord, pleased to pass an order, my lord, will please to take pages 46, 47, my lord. My lord, this was an order, my lord, passed,
Yes.
where, my lord, the second paragraph, my lord, we were agreed by an order, my lord. They had come up, my lord. This was, my lord, just takes the prior page, my lord, 45 once. I'm sorry to trouble, my lord, with the page 45 once, my lord.
Page 45.
My lord, 45, this was the order of the trial court, my lord, the ordering portion. The defendant is hereby directed to remove the padlock from the pump room and electricity room for the purpose of easy access of the said rooms by the plaintiff. This was, my lord, defendant is the other side, my lord, the OP here. My lord, there, that was, my lord, next page. They carried this in revision, my lord, before this honorable court. My lord, this honorable court, my lord, after hearing, my lord, had been, my lord, next page, page 47, my lord. And under the aforesaid circumstances, the order dated December 16th, my lord, the middle of the page, is modified to the extent that every morning from 8 a.m. to 9:30 a.m., the meter room and pump room locks shall be removed by the defendant in order to enable the plaintiff to operate the pump room, my lord, and also to check the meter as and when necessary. My lord, then, my lord, they had prevented us. My lord, next page, page 48, we lodged a complaint, my lord. This recently they were preventing us. My lord, then we filed an application, my lord, page 62. My lord, 48 to 52 is the complaint which we had recently lodged, my lord.
Yes.
My lord, page 62, my lord, is my application. Prayer is at, my lord, page 65.
Opposite party number 3 is a practicing advocate of this court. I know him.
My lord, no, my lord knows him.
Yes. That's why the name struck.
My lord, that is the reason why. Someone saying, my lord, we'll have to go for, my lord, some judge who's not a man.
Yes.
It's not from. Grateful, my lord.
But, kindly fixes that date, Milord. I'm not prepared today. Kindly fixes that.
Very well. It has come up as to be mentioned. I'll fix it also. Liken. Divisional application has none. Sorry. This matter has been assigned.
Settled between the parties. I have instructions to withdraw. Lordship, may I kindly file the instructions?
The Dean.
It has been resolved between the private parties also.
Very well.
It's a pertaining to high tension line, Lordship.
Mr. Kothari, learned advocate, appearing for the petitioner,
Lordship.
petitioners, hands up to court. A printout of an email dated July 14, 2026.
Objection.
Lord,
That's why.
On two times, on 7th November 2025, they gave us a communication where the reason for not giving the connection was main switch not installed. Thereafter, on 30th March 2026, they say that they did not say that the neighbor is objecting. What they said is that way leave permission is required. So we don't know what is the name of the neighbor. If the name can be provided by us, we can implead.
Names of the persons who are objecting, so that they
Verbally
can be
objection, my lord. Verbally objection, my lord.
verbal objection is no objection. Why
There is no objection.
But it's accepted, my lord.
My lord, we are ready to bear the costs.
Cost we are the.
We are ready to bear the costs.
And you have the place where the poles can be installed.
My lord, that I think they have to decide, my lord.
The place where the pole is supposed to be erected, that place you have selected.
Yes, my lord.
What is the nature of the objection that is being raised?
Uh,
You please file a report that will make
Yes,
it clear.
Lordship, the council stands for the petitioner. I'm aggrieved by the inaction of the CSC authorities. Lordship, I'm staying at the said premises since last 5 years. I've made an application for obtaining the electricity connection in the year 2021. And subsequently, the CSC authorities visited the premises and made the inspection. Later on, an electricity meter was also installed at the said premises. Correspondingly, respondent number 4, being the brother of the petitioner, raised objection and consequently, the authorities people left the said premises. After that, I've made several attempts to obtain the said connection, but I failed miserably. Later on in the year 2026, dated 4th April, I again made a complaint for obtaining the said application. But Your Lordship, I was provided with no result. Rather, it is showing on the online status that the problem has been resolved.
The petitioner is in occupation of a single room in the ground floor of a premise. My lord, that is not a self-contained domestic occupation. And upon inspection, we found that she is already deriving connection categorically from Sri Shujit Bormon, and the meter room is specified in the inspection report also. So, my lord, it is a clear case of splitting of load which can be referred to the GRO.
Lordship, the very first date when the CSC authorities went for the inspection was done. Already the electricity meter was installed. It was after
letter rejecting their case for split load.
That's a notice that they've sent it.
The letter also to them that it is a case of split loads because she was deriving connection from another meter.
Lordship,
already.
it was learnt by indeed, Your Lordship, but it
Why
was
don't you take steps against this? There is a remedy available to you under the regulation.
Your Lordship, everyone, like I've been visiting the office, he's been telling that get the order from the Honorable High Court. Also, Your Lordship, a fact remains.
Remedy of appeal, I believe, against this,
Okay.
against an order passed by the CSC authorities or the electricity licensee rejecting your application on the ground of split load. There is a remedy of appeal. What is that regulation?
GRO regulation 72. GRO
Lordship,
can be referred
but a
to
fact
the
remains that
Grievance redressal officer.
the premise.
This is a factual question whether there is splitting of load or not, and as she suggests, which you have not denied, that you are in occupation of the same premises, you are a part of the same family.
Lordship,
Family member.
Lordship, I'm occupant of the same premises. That's an admitted fact. However, the accommodation are two separate things.
The application is 2020.
Accommodation in what sense? You have a separate kitchen, everything.
Indeed, Your Lordship, we are staying in two separate accommodation, which is why when in the 2021, when the electricity authority.
If they have wrongly rejected it, move the appellate authority and get an order there. If the appellate authority does not hold in your favor and you find that still something wrong is there, you can come here, because the factual disputes, the writ court will not be able to decide on the basis of affidavit evidence. That the authority is there. We should allow the statutory mechanism to be activated, right? Because every time we come up in appeal, we are shunting that mechanism. There is a regulation which puts in place a statutory forum. Approach that forum, get your grievance redress there. If you don't get a redressal, the writ remedy is still there. Why at the threshold come to the writ court?
My lord, I have the pictures also, my lord, and the application is way back in 2021. So she must have been deriving supply. Otherwise, this is 2026, my lord.
Lordship, with regard to the notice, I'm unaware. I'm completely clueless. I have no. Hey, I'll come back tomorrow after taking instructions from the client.
Then on Monday, my lord, can this be?
I've just served the copy, received the copy.
The writ petition
appear for the petitioner, my lord. I'm praying for, my lord, electricity connection to my premises. Lord, rather, my lord, if I take your lordship through the papers, my lord, it would be, my lord, implementation of an order passed by this honorable court, my lord. There have been successive orders, my lord. I've been successful all throughout, my lord. But for some reason or the other, my lord, I'm still without electricity. Although, my lord, my application was made in the year 2011, my lord. That's the first time that I make an application.
Mr.
My
Naik,
lord,
why
what
is it
happened,
not-
my lord? They are approaching your lordship in gross suppression. Because the court directed the BLRO you make inspection because he is not in a position to allow us to have any free access. His area is non-accessible, surrounded by, my lord, agricultural land. All persons are, my lord, opposing initially, and, my lord, ultimately other persons they allowed, my lord, they wanted to give some land for preparing, my lord, road to their house. But this person who is asking for electricity, he is strongly opposed. He will not give anything. BLRO, my lord, prepared report in their presence, and the report I am handing over to your lordship. They are fully aware of it. And after 2 years, this inspection and report was prepared in my lord, on 24th, 27th of May, 24th. And he is the person he is opposing. And at the same time, he is asking for electricity. What we want, my lord, we want free access. Let him arrange free access, my lord, we shall give connection. We have no objection. But fact remains, all other persons, though, who will be prejudiced, because this person is using their land to have access and ingress. Now, my lord, they are, my lord, giving some land for preparing, my lord, small way so that path can be prepared, constructed. But he is not giving. He says, no, I will not give. I will not make any sacrifice. Let them give. I will walk through their land. That's the situation. Therefore, we are not having, my lord, any way leave. Let him give, my lord, way leave. We shall give connection. No issue. I am the report, my lord, may hand it over to lordship for looking into it.
May I have a
Language,
copy?
you are fully aware. These all the reports.
May I have a copy of the report that what kind of submission is this when I'm asking for
I
a
am
copy? You said
giving-
you're aware of it.
giving-
I will not give the copy.
Sir, I am giving. When you approach the court in gross suppression, you are alleging.
Let's see who's suppressing what, my lord. Let's see who's
My lord,
suppressing
come
what.
to this report. The last part. This is the report prepared by BLO revenue officer written to BLO. Last two paragraphs, 3 paragraphs. গ্রামবাসীগণের দাবি প্রথমে যাতায়াতের জন্য
Where are you reading, Mr. Naik?
Lordship. I am last 3 paragraphs. I am just reading.
Last 3 paragraphs.
Yes.
প্রবাসীগণের
Yes. My lord.
প্রবাসীগণের
Yes. গ্রামবাসীগণের
গ্রামবাসীগণের
yes. দাবি প্রথমে যাতায়াতের জন্য রাস্তাটি তৈরি করা হোক, বিদ্যুৎ সংযোগ হয়ে যাবে। এর জন্য পার্শ্ববর্তী রায়তগণ তাদের নিজ নিজ রায়তি জমি ছাড়তে চাইলেও আবেদনকারী সাইদার আলী রাস্তার জন্য জমি ছাড়তে নারাজ। অথচ আবেদনকারী অপর রায়তগণের চাষ জমির আল দিয়া যাতায়াত করেন। আবেদনকারী জেদ এবং একগুয়েমি মাননি করার জন্য সমাধান করা যাইতেছে না। সামগ্রিকভাবে সমস্ত বিষয়টি আপনার অবগতির জন্য জানালাম। So substance is this, my lord, he is not in a position, he will not give any land to prepare, my lord, to construct the pathway. Therefore, we are not having any access. Law requires, my lord, free access is to be arranged by the petitioner. If he can arrange it, we are always ready and willing.
If the dispute as regards pathway, it has to go before the district magistrate.
Everything done, my lord. Once my land final finishes submission, I'll make my submission.
Where is the order of the district magistrate? Show me.
Well, may I take your lordship, my lord, sequential, because a lot has been said, my lord, which is absolutely contrary to records, my lord.
Show me the order of the district magistrate.
Sure, my lord. Kindly comes to page 26.
Yes.
The petitioner agrees to the proposal that a path will be, and I'm the petitioner here, that a path will be constructed taking equitable portion of land from the rayats of both sides of narrow strip of passage which are being used at present. On considering the above facts and observations, the undersigned hereby orders the BLLRO Ramnagar will demarcate the outer line of the proposed approach road and pegging within 4 weeks from the receipt of this order. An assistant engineer and station manager will extend electric connection to the residence of the petitioner as per provision of law. An officer in charge will provide all sort of assistance for enforcement of this order. My lord, this order was not enforced, so I had to come up.
But prima facie, it appears that it was not enforced because of your non-cooperation.
What?
You kindly
No.
see page 26, which you just now read.
Yes.
Kindly read the first line. You agreed to the proposal that a path will be constructed taking equitable portion of riots from both sides of the narrow path.
I'm still agreeable.
He says, the report says it is, you are not.
Where is the
agreeable.
signature, my lord? But today he comes up with a report.
You are agreeable to give the
Absolutely, my lord. No.
agreeable. What is the problem? I'm keeping it pending. You go and demarcate. He is agreeable. You give him line.
Very well, Lordship. Then, my lord, 20th of, my lord.
may I show a few more pages, my lord? And well, it would be absolutely crystal clear, my lord, as to what is happening, my lord, behind the curtain. As to what is happening behind the curtain, my lord, that it will.
He's agreeing. I'm recording his agreement in the order.
Yes, yes,
and,
yes,
go and execute.
Let him, my lord, construct the pathway, wayleave. Let us give us wayleave. That's it, my lord. Edit.
If I show the orders, my lord, that has been passed, my lord, by this honorable court, my lord, coordinate benches, my lord, every time I've been successful, and every time they come up with some. So it is not for electricity. What the Gram Bashis are saying, that before providing electricity, we are aggrieved because there is no road. So first you have to construct the road, and then you can provide electricity. So it is not about electricity. It is about a road not being constructed for years, perhaps.
No,
So
but Mr. Counsel, it is a sort of quid pro quo here also.
No,
what right you have to compel the Grambasis to forego their right in respect of their pieces of land? They are doing it in your interest. If you don't be so selfish. You are.
May I explain?
They are doing it. They are doing it in your interest. When the question comes for construction of a common pathway for the benefit of the entire village, you are not willing to let go an inch of your.
My submission. I am willing. I have no because
the willing.
Help.
Let him prepare the wayleave
If you
and
want
inform us.
equitable, if you want equity, do equity. If you don't let an inch of your property be gone for the purpose of the villagers, then you can't expect the villagers to let their properties also go in your favor. It can't be done that way. It has to be both way.
Absolutely, it's always quid pro quo, my lord. I absolutely bow down to what lordship has observed, my lord. In fact, I say, my lord, kindly record my submission. I have always been willing, my lord. My lord, as I said, my lord, what is happening behind the curtain, that has not been placed by my learned friend.
Very well. Now it is clear. Now I'm recording it.
Yes, lordship records it. Let's see, my lord, what excuse they come up with now.
Next.
Yes, my lord. Yes, sir. My lord, this application has been preferred due to the inability of the CSC to provide the connection because of the objection being given by respondent number 3, sir.
My lord, there are
Respondent,
Yes.
private respondent is there,
Sir, he has not appeared, sir. Respondent number 3, sir.
making it not today.
Yes.
Because
Not to pass adverse order.
Sir, there are two issues here. A common passage has been identified by the petitioner.
let the private respondent come in any case. এটা ফেরত দিয়ে দিন, not today করে দিন।
And my lord,
ফেরত দিয়ে not today করে দিন।
my lord, one more indulgence. My lord, item number 12, I have handed over the copy of the letter to the petitioner, sir. That I forgot.
I have recorded that.
Great.
I am appearing on behalf of the petitioner hearing. My lord, I am praying your lordship's kind leave to withdraw the instant matter due to informal defects that has been crept in the petition.
Is this a surfacey matter?
No, my lord.
Then I don't have-
Say we.
the National Stock Exchange.
I don't have determination.
My lord, I'm praying for.
I was
I don't
I'm-
have determination. I will not have determination.
For the petitioner.
I have instructions to appear on behalf of only one.
I request your lordship to kindly take up volume 2. There are 4 volumes. 5 volumes. Volume 2, page 249.
49.
249.
Yes.
Well, this is the first demand notice under section 13(2). My lord, declaring the accounts of my lord, NPA on 10th May 2020. Your lordships will find that at paragraph 250, my lord, page 250, third paragraph.
Yes.
Your lordships,
Yes.
my lord, your lordships can read it. 10th May 2020. Then your lordships kindly consider page 267. This is notice dated, your lordships, 7th May 2021. Page 249. This is 7th May 2021, declaring NPA on 10th May 2020.
267.
260.
Yes.
Then 267, your lordships will find second NPA notice. Notice under section 32. Your lordships will find this was issued on 7th November 2023, page 266. And the next page, last paragraph, your lordships, 10th January 2021. There are 2 dates declaring NPA, your lordships. First, 10th May 2020, and the second, 10th January 2021. Then your lordships will find at page 267, they have mentioned that there was earlier demand notice dated 7th May 2021 stands withdrawn. So the second demand notice declaring NPA stands. Now, your losses kindly take up questioning a lot. Certain an section order passed under section 14 under the Surface Act, and the other we moved before this honorable court, page 394 at volume 3.
394.
4. On order dated 17th March 2025. May I take your losses because this is the first order genesis of everything. The petitioners are aggrieved by the steps taken by the respondent number 4 in approaching the district magistrate under section 14 of the Surface Act. The order of the district magistrate dated 4th February 2025 is impugned herein. The same records that the borrower committed default in repayment of the financial assistance and the account of the borrower was classified as non-performing asset on 10th January 2021 due to non-servicing of interest and installment. The district magistrate, upon satisfaction, passed order for taking physical possession of the secured asset within a period of 6 months from the date of receipt of the order. The secured asset is a nursing home, mortgage property, a running nursing home having good number of beds and a very running nursing home. The securitization application has been filed by the petitioner before the Debt Recovery Tribunal seeking declaration that the classification of the loan account as NPA and the steps taken by the respondent number 4 for recovery the accrued amount is illegal and the said application is pending consideration. The order passed by the Honorable Supreme Court on 3rd September 2020 in the matter of Gajendra Sharma versus Union of India reported in such and such has been placed, wherefrom it appears that the Honorable Court was pleased to direct the accounts which were not declared on NPA till 31st August 2020, well, can you take that, shall not be declared as NPA till further orders. The issues to disposed of by the Honorable Supreme Court of 23rd March 2021 in the matter of such and such. In the instant case, it appears that the loan account of the petitioner was classified as NPA on 16th January 2021. That is the period during which the order passed by the Honorable Supreme Court in the matter Gajendra Sharma was subsisting. The district magistrate possibly was not made aware of the order passed by the Honorable Supreme Court, and accordingly the district magistrate went on to pass the order for taking physical possession of the secured asset, relying upon the declaration of NPA by the respondent number 4. The fact as to whether the respondent number 4 could have declared the petitioner account as NPA on the subject date is pending consideration before the Debt Recovery Tribunal in the securitization application filed by the petitioners. The said application is likely to be taken up for consideration by the tribunal shortly. Learned advocate representing the respondent for submits that the instant writ petition is liable to be dismissed as alternative remedy is available to the petitioners in subsequent proceedings. The securitization application filed by the petitioners is pending consideration before the Debt Recovery Tribunal, which is functional at present. 6 months' time has been granted by the district magistrate to execute the order passed under section 14 of the Act. In view of the above, the respondent number 4 is restrained from taking any step to implement the order passed by the district magistrate on 4th February 2025 till 16th May 2025 or until further order whichever is earlier. The petitioners are granted liberty to approach the Debt Recovery Tribunal by taking out application to bring on record the order passed by the district magistrate on 4th February 2025 seeking a necessary relief. If an application is made by the petitioner, the tribunal shall consider the said application in accordance with law. This was the order passed. Now your losses will find the on 397. We went before the tribunal.
Tribunal kept the NPA.
My lord, kindly your losses considered the application dismissed, keeping the point of NPA open. Our point was that if the declaration is bad, then the proceedings is vitiated. So that has to be decided first. In spite of the order of this honorable court, kindly consider page 398. Facts recorded all that.
409.
my lord, 409, your lordships kindly come to. Just page 409, continuation part. Just after the, my lord.
This order of DRT, you did not move the appellate forum. DRAT?
No, the losses. The issue of NPA is kept open, page 409. Just after the longest paragraph at the top, the issue of NPA is kept open to be decided by the tribunal at the time of final hearing. The court directed to decide that issue first. And then, my lord, all the orders were passed. Then your losses kindly take up what happened. My lord, we moved this honorable court again. Your losses will find page 448 at volume 4.
Yes.
Now, kindly see, my lord. The petitioner is aggrieved by the order passed by the Debts Recovery Tribunal on 9th August 25 by observing the issue of NPA is kept open to be decided by the tribunal at the time of final hearing of the securitization application. According to the petitioners, the entire issue relates to the declaration of NPA. The petitioner asserts that the NPA was declared contrary to the direction passed by the Honorable Supreme Court. Prayer has been made seeking for a declaration upon the direction upon the tribunal to take steps for early disposal of the securitization application so that the primary issue in the securitization application may be decided. The learned advocate representing the financial institution submits that if the petitioners are aggrieved by any direction passed by the petitioner ought to have approached the appellate forum. Then your loss. It has been denied that the NPA was declared in any manner contrary to the direction order passed by the Honorable Supreme Court. Upon hearing the submission on behalf of the parties and perusal of the direction passed by this court on 17th March 2025, this court disposes of the instant petition with a request to the learned tribunal to make an endeavor to decide the issue of declaration of NPA at the earliest without granting any unnecessary adjournment to any of the parties. Now your losses will find what was the past, my lord, on 15th, 532 page. My lord, volume 4, the same volume, my lord, 532. Only the now I am not taking your losses entire portion how this was disposed of, kindly consider. Order dated 15 December 2025. Last paragraph. The respondent financial institution has issued 2 demand notices under section 13(2) of the Act, 7th May 2021, and subsequently issued another demand notice under section dated on 7th November 2023, and 13(2) notice dated has been clearly stated has been withdrawn. Correctly noted. Then your losses kindly come, my lord. After just 3 paragraphs, it appears from notice under section 13(2) dated 7th November 2023, and the loan account of the applicants has been declared NPA with effect from 10th May 2020. But the learned DM has recorded in the purported order 4th February 25 that the date of NPA, which is not true. Then 10/1/21, which is not true. Then your losses kindly come to the next page. And I think 533 last paragraph. SA applicant, however, has also written in paragraph 13 of the instant application that the loan account of the applicant was declared NPA with effect from 10th May 2020, and in paragraph 20 it has been submitted that the loan account of the applicants has been classified NPA with effect from 7th November 2023. I find that the loan account of the applicants has been classified NPA with effect from 10th May 2023. Absolutely wrong finding based on facts in spite of recording, and disposed of the application. Absolutely in regard to date, made in regard to the date. Now, Lord, we came before this honorable court. Malad, your lordship, 567. page 567. Now, we approach this honorable court again. The checkered history between the parties here to cover 3 rounds of writ petitions, several rounds of litigation before the Debts Recovery Tribunal. The final order passed on 16 December 2025, passed by the, which is not a part of the, but is assailed nevertheless, fails to take into account the actual date of declaration of the petitioner's account as non-performing asset by the respondent financial institution. The petitioners have a statutory remedy before the Debts Recovery Tribunal, or if they so desire, before the Debts Recovery Appellate Tribunal. The petitioners are well aware of such remedy and are statutorily required to avail of such remedy before invoking the jurisdiction under Article 226. The petitioners will be at liberty to urge the issue of Section 14 of the Limitation Act before the tribunal or the appellate tribunal. The tribunal is requested to decide the issue finally before undertaking any further proceedings in connected with SA 712, as a decision on this issue will decide the future proceedings against the petitioners. Then, my lord, we approached, my lord, by filing a review application. Your lordships will find that at page 586, the order passed on the review application.
Yes.
Now your losses will find 586, your losses will find, kindly skip over the first 3 paragraphs then. The Honorable High Court also directed tribunal to decide the issue of Section 14 Limitation Act before undertaking any further proceedings. My lord, probably, my lord, this was not the direction. Direction was the issue of NPA to be decided, but since there was a time gap, Section 14 I can invoke before the tribunal. Now, Section 14 of the Limitation Act provides for extension of time for proceeding bona fide in court without jurisdiction. The applicant filed on a writ petition on such and such date, challenging the order dated such and such. The Honorable High Court passed allowing the petitioner to challenge the order of marriage before the tribunal, raising a Section 14 of before the tribunal. So, as per section, the period of litigation till such has to be excluded. The respondent bank submitted the review application is not maintainable and the same is filed beyond 30 days. The applicant filed recall order dated and review application has been filed on such and such. After excluding the period of litigation before the Honorable High Court, the review applicant has filed the review application after 1 month, 16 days, and Rule 5 of the DRT procedure prescribes period of 30 days for filing any review order. Rule 5 prescribes that no application for review shall be made after expiry of 30 days from the date of the order. Normally, since the review has been filed, the same is not maintained. He approached, my lord, my pedantic approach has been taken.
But this is again an appealable order.
My lord, appealable order, your losses knows what happens to that. I have to pay the entire thing. Every appealable order. My issue is the NPA is not properly did.
That is genuine. You have to prefer it because after Supreme Court's directions, it is difficult now because this is an appealable order. Problem is you have approached the writ court also after expiry of the period of appeal.
After expiry
period for
then that's why, my lord,
that again.
No, my lord, I tell you, lordships, my lord, Justice Mitra's order, considering all the facts. Now, my lord, if I read the order between the lines,
if you leave to go there only,
leave only and to decide the, my lord, if I go place the order once again, kindly have a look at this. Page, my lord, 532, if I'm not wrong.
Was this writ petition, why was this not preferred within the period of appeal then?
My lord, I request your law.
Mr. Sanyal, on these laws, at least on SURFACE laws and on fiscal laws, the procedure has become very, very strict and stringent. We are to follow an ironclad procedure now. There is no deviation. Whatever deviation we used to have been struck down with vehemence by the Honorable Supreme Court, saying this is not
with request your lordships, kindly do not view this justice should be tailor-made. Is it not wrong expressly before your lordships?
Mr. Sanyal, if you ask me to express my mind, there is nothing wrong. Why I say so is because this classification of NPA in 2021 was never prohibited by the Supreme Court. If you see the regulations, the Reserve Bank of India regulations which were there in force, the regulations had said that the classification of NPA will be deferred across the board till such time that a further regulation comes in. there were several regulations beginning March or maybe April 2020 when COVID first set in, and they continued till August 2020. Thereafter, there was no extension. The Honorable Supreme Court was approached in that Gaurav Singh's case. There was some small association manufacturers or some other case was there. Justice Ashok Bhushan was a member of the bench. There was a detailed order saying that no, it was only a deferment. Now, upon the period ending, the borrower was supposed to replenish the entirety of it. If he failed, that then the account will be classified from the date on which it would have been classified as NPA had the deferment not been there.
My point was that if the NPA was declared during the validity period of the interim order, admittedly, my lord.
No, the 2023 notice recalls the first notice.
Because the first notice was not, my lord, in violation of Supreme Court order. Second notice.
It is also not there because the second notice is issued in the year 2023, classifying it at a point of time
when there is an interim order.
Yes, but that is not the case. Supreme Court, when the notice was issued at that time, the interim order was not there.
You have made it NPA, notifying subsequently. That doesn't carry any
No,
meaning.
that is what has been clarified by the Supreme Court in that small association or manufacturer's case, that it was only deferment for that period to give respite to people who were suffering from COVID so that they will not be able to pay. Therefore, you don't pay now. Now it will not be classified, but upon the period ending, if you don't pay, the classification will date back.
They do it unless this is done.
The classification will date back, Mr.
No, this was not done in my case. I could not proceed because of declaration of NPA. I could have paid it. I could have paid for
no, NPA declaration doesn't prohibit you from paying. It is a falsity that NPA declaration, or either a misconception that NPA declaration will not entitle you to payment. You are always entitled to pay. You can upgrade. There are provisions. Prudential Master Circulars also say that if you pay, the account will be upgraded from NPA status above.
This case I have to consider. I could have placed my case.
You could have.
But how the tribunal proceeded, the recovery tribunal recording wrong date.
For that is again, if the you know it well, even if the tribunal
of mine,
even if the tribunal has recorded wrong dates, if from the records it appears that the dates are right at conclusion of
correct finding,
ultimately the conclusion is the same because
the conclusion he has not arrived at any conclusion.
So if I enter into it, I will be able to arrive at
that's
that
different
conclusion.
issue, my lord. Kindly
Because,
do not put there. Now what happened? I have filed another application. Please hear out this. That is pending, hearing is going on.
Be heard out. I'll direct that.
That is going on. Now, what they have now done, they are now every time coming to my nursing home and says, I will survey, and 20, 25 numbers of people coming in the running nursing home. Patients are objecting to this. So all that I am paying, my lord, kindly dispose of the essay within certain time. And till such time, they do not disturb my running of business.
Yes, Mr.
That's my point.
Mr. Bhattacharya, why should you disturb? You have
all the documents I have annexed.
You have at your disposal the steps that are available to you to be taken under Section 13(4). You will do whatever is available to you under Section 13(4). You don't have right to barge into someone else's property until you take physical possession in accordance with law.
And in by way of this, they are trying to do that.
Now, two things first. February 2020, last EMI paid. 16 crores is the principal amount. EMI was about 17 lakhs. Citing this NPA and no NPA and when it was declared, how it was declared, one after the other, endeavors have been made to prevent effective measures from being taken. We have initiated 13(4), no stay. After the intervention of this Honorable Court, Your Lordship was invited to page 567, Justice the Coordinate Bench's order. Post that, that is a 2026 order. Prior thereto, another Coordinate Bench directed the matter to be disposed of on this issue within 19th of December. That was done. Not favorable to him. Ordinary remedy lies in appeal before the DRAT section 18, 50% deposit. As a financial institution, by giving a loan, we have not committed a crime. Our loan agreement permits us to go and conduct surveys. We have the loan agreement with us. And my lord, no one, my lord, today are running nursing home in BT Road, prime location, every day it's running. Our dues against a loan sanctioned amount of 16 crores, the amount till date has been paid, my lord, 2018 sanction, we are running, my lord, 8 years. 3 crores and 37 lakhs has only been paid. After December 2025 order, my learned friend comes to your lordship's court, coordinate bench directs the DRT or DRAT to be approached. He approaches the DRT. The DRT again, my lord, rejects his application. What was his application? A review, a recall. Again, he has filed another application, again a review of 15th of 25th March. This order, page 586, has been sought to be reviewed now, again by way of an application. And the entire endeavor is, I will enjoy public money, not pay a farthing, and go about, my lord, filing one after the other applications, not secure the money. My lord, I am wrong. Let him secure 10 crores. Let him produce the check, my lord, a demand draft tomorrow. Let me see some color of money. My lord, for last, he cannot dispute. His case is NPA wrongly declared. No one has, no forum till date has come to his rescue. There is no stay. There is nothing. One after the other applications. My lord, what little that we have learned, my lord, mere filing of this sort of an application, my lord, today your lordship has just now spoken. My lord, today, my lord, we also appear for private entrepreneurs. It's not that I am ordinarily a financial institutions lawyer. But my lord, kindly visualize our predicament. Loan sanctioned, only 22 months EMI paid. Records reveal that. And he can't dispute. Post January 2020, prior to COVID, 24th March.
What is the situation of the essay?
It's ready for hearing. It's ready for hearing.
My lord, essay.
Kindly,
I'll direct the essay.
My lord, kindly ask him to secure some money.
On his writ petition, what I'm not staying anything. The essay I'm expediting the hearing of the
essay, your lordship, that is not the relief which he has paid for. He wants
always grant the lesser relief.
Only this much. Only this much. Kindly pardons me for saying
you don't want the essay to be disposed.
That is essay is another thing. Essays.
You don't want it to
yes,
be
yes, essay, your lordship decides.
That's what I'm directing.
Only this much. That we are in complete, section 14 order has also not been interfered with by any forum.
I'm also not interfering with that.
And that is
today, my lord, if today upon notice we go on the 3rd of July, my lord, objectionable behavior. My lord, I will say something, he will say something. The issue is, my lord, a nursing home with 100 beds. And his pleading is, there are 90 patients as on date when the writ petition was filed. My lord, 90 patients, my lord, with all humility.
Mr. Bhattacharya, on his writ petition, I will not direct payment to you suddenly unless I grant stay. I don't grant him interim order, and I ask
therefore,
him
your lordship will also not, my lord, prevent any more. Since the question was posed to me, why are we going? My lord, we are going to, my lord, carry out a
see, you are not only
valuation.
Mr. Bhattacharya, you are not only a private money lender. You are also a statutory organization bound by the statute. You cannot do anything which is beyond the statute.
With respect, we are only going there to conduct a valuation of the premises, of the property. So, kindly clarify that. That is what we are. Please see our notice, what we intended to do. Please come to, page 647.
647.
647. We intend to visit, this is the notice. This is a notice, my lord, dated 24th June 2026. My lord, a part of 646. It begins at 646. It ends at 647. My lord, what we have said, we intend to visit the mortgage property on 3rd July during office hours. In case of your non-availability, you are requested to inform. Kindly ensure that such inspection is carried on lawfully and peacefully without any illegal hindrance. And the purpose of this is,
Mr. Sanyal, the mortgage property bank can always inspect.
My lord, I am not on that. In the name of and under the garb of notice, they are disturbing the treatment of the patient
no.
also. That's
The absolute-
what should I 25%. They're entering with 25%. Are they wanting to take possession?
Why should I put this question.
He will take in accordance with law if he is putting.
Why should I? Then I'll go about disturbing.
Kindly look at the photographs. How many people are there?
650 crore. That from photographs, Mr. Sanyal, how
No,
will I know?
Therefore, your lordship, there are people.
Visitors.
There are people. All that I'm saying that till essay.
This 5 people visited. One of them is in court. Your lordship will pin us down. But we are entitled to visit the premises and conduct.
Visit, madam, no.
As a credit
in
secured
name
creditor,
and
they are
under the
always
garb of
entitled to
visiting, they
inspect.
can't
Because they have interest.
No,
in the
they
property.
don't want people to know. Mr. Sannal's client doesn't want people to know that they are in default of 84 months loan.
Very well. I am disposing this off, directing the essay to be disposed of.
And
the applications, whatever.
Yes, whatever
Not application, whether it is maintainable, that is review.
Mr. Bhattacharya, you are now objecting unnecessarily. Objections will have to be disposed of in accordance with law.
Yes.
If they are maintained, I am not directing them to allow the applications.
And your lordship will, if it comments.
Hear me, whatever.
Only one sentence more. If I leave it to you. I leave it to you. Kindly fixes a date. We'll go and conduct this survey. Kindly fix a date.
They'll go on a date and conduct the inspection. That is better.
Anytime next.
What?
Inspection of the property, mortgage property, they are entitled to inspect.
For valuation purpose.
That's a loss.
Yes, of course.
For valuation purpose.
Why not?
Yes, that they are entitled.
That's kindly still the hearing of the AC.
No.
Valuation, because there was no stay of the possession.
NPA issue to be decided first.
Will be decided.
Now, please see.
But if upon valuation they proceed further, then
you are entitled to. They will issue a sale notice. You are entitled to challenge that before the DRT again.
that's
Every step is a saleable.
instead of that, kindly
Because valuation, it can't be without valuation. I cannot stop valuation. That is something which is primary. Has to be done by secure creditor.
Instead of that, what I'm praying, kindly direct the essay to be disposed of with a time-bound manner. Till such time, let them not to do like this.
No, Mr. Sanyal,
That's my prayer.
that will be an illegal order, because I know
হয় না ফ্রিজিং করা
Lord, may I permitted to mention two chamber application for inclusion in your lordship's list. Chamber application new and
I have a similar player for inclusion under the
Lord, I have another prayer in respect of the testamentary suit in respect of 2023, which was due to appear in the list but not appearing.
My lord, may I have your lordship's kind leave?
and one more prayer, my lord. I have a non-prosecution matter. I hand over this slip to your lordship. Yes. Yes. I shall.
Chamber application. May I have your lordship's kind leave? This is
My
an
lord, may I mention?
construction of the file, my lord. Record which was before the my lord's department, that record has been water soaked and been demolished. My lord, the record which is in connection with this PLA matter, my lord, has been water soaked and has been destroyed. My lord, I have filed an application for reconstruction, my lord.
Lordship, may I mention? Lordship.
My lord, I am being led by Mr. Sanjay Mukherjee, my lord. The mentioning.
In fact, Lordship, don't take me. His Lordship's voice is inaudible. I am unable to hear anything.
Now you can hear me.
Yes, my lord. I'm so obliged. My lord, this is a company application which I'm mentioning. This arises out of a BIFR proceedings. Now, we are the auction purchaser. We purchased the property of 25 acres in Kharagpur and had set up our industry through the official liquidator through auction purchase. Now, the exchange of deeds have been effected. We have already invested about 25 crores in the project. We are setting up our factory. The deeds have been exchanged. Deeds have been approved. WBIIDCL, West Bengal Industrial Development Corporation, is a confirming party to that, but WBIIDCL is not party to the present proceedings. So, Lordship's coordinate bench suggested that we should take steps to bring WBIIDCL implicit as a party so that they can sign as a confirming party. That application I seek to move.
You have filed it?
Yes,
We have already filed it.
Give it. Let us see. It will appear. Addition of party.
Yes. Implement application?
Yes. All the list.
If Lordship
May I mention one application?
My lord, I have handed over the list.
We shall see. Please give the lists.
My lord, I have handed over the slip of the matter which Mr. Mukherjee just now mentioned.
I'm so obliged, my lord.
My
Yes. What was the application for? Probate or letters of administration?
that was for probate. Probate.
মেন অ্যাপ্লিকেশন আছে না এখানে নেই কিসের জন্য ছিল তাও তো জানি না এখানে কিছু লেখেও নি যে ফর প্রবেট ছিল নাকি লেটার অফ অ্যাডমিনিস্ট্রেশন ছিল
Great.
Deceased. Yes.
to the grant of probate, my lord. It was March, my lord, matter got dismissed. And I have specifically stated in paragraph 3 to 5, my lord. The grounds.
Application was for probate or letter of administration? You understand my predicament? It's not that I can take up on my own and do whatever I feel like. I have to follow the rules.
May I be very candid with your lordship? If your lordship permits me, sir, we were not even allowed to explain ourselves on that day.
That's
the thing. That's where
I don't
lies the
have
crux of the
jurisdiction to
difficulty.
enter into this because of this language of the dismissal. Because the dismissal, if it was none appears dismissed, that's restoration, pure and simple.
Your lordship is absolutely correct.
Determination says, recalling yesterday I posted it for today because I thought, no, I'll give it a thought. I said, no, I'll restore, even if the prayer is for recording. But with this kind of observation, I again cannot.
My matter, I can tell your lordship what had happened. In my matter, but
That may be a statement of fact, but that will not enable me to correct something in someone else's order. That I cannot do. I don't have the jurisdiction.
because
ঝামেলা আছে।
the reports didn't.
I'm releasing all of them then because it doesn't make sense.
The reports also were not placed before the honorable bench on that day.
অ্যাডভোকেটরা চলে গেছে নাকি? এটারা তো চলে গেছে। বলবে যে অর্ডার পাস হয়েছে, ওদেরকে তাহলে ডেকে নিন একটু। ফোন করে ডেকে নিন। হ্যাঁ। You are there, na?
Yes.
Yes. এটা ধরে নিন, ওয়ানটা নিন। Let us do one thing. I'll take one more try. Not today করে রাখুন, সোমবারে রাখুন।
Monday, your lordship.
Monday.
Lordship.
Please inform the other advocates who were there
Lordship.
prior to this. আপনি পুরোটা একবার কল করে দিন 2, 3 না 3 and 4 2 তো কেউ ছিল না।
Madam.
There was a lady advocate, your lordship.
Yes. ফোন করে একবার বলে দিন যে ওটা inform them that
I was there.
these will appear in the list on Monday because the order is of a different nature. I went through it. It's not simple dismissal for default. Saying
No, it's
that
not
irregularities
dismissal
are there, those have not been cured, therefore it is dismissed. So it
My lord, actually in e-court status, that was not shown as dismissed for default. One other nothing. One other date is also there. A future date.
এই ফাইলটা একটা ফাইল যে কোনো নিয়ে আসবেন, কথা বলুন।
Your lordship, item 7, this is my application for grantal of
And
letters.
the order,
Yes.
nature of the order is the same.
The rest of the order is the same, your lordship. If your lordship kindly takes up page 48, the order is there. Page 48.
Not required. It will be wastage of time. ছেড়ে দিন।
8. I am for the 8.
My lord, item number 9 kindly takes up the order. It is simple dismissal. 9. PLA 196.
There was no irregularity.
No, my lord, page number 6.
Yes, this is different.
My lord, I have explained the reasons in paragraph 8 and 9.
This is right. This is dismissal for default. None appears, no accommodation, dismissed. কালকে রাখুন। Sorry, but I also need the clarity.
In all the
I would
applications,
not like to pass an order which ultimately will be said to be without jurisdiction.
in all the applications which have been, which are before your lordship, which contain the order, which are against the order dated March 31, 2026, all contain the same recording. Same. One single order was passed in every matter, and all 50 matters. There were 50 matters.
If it was simple dismissal for default, I would have restored. It is not that.
I can understand it.
And the determination says that for recalling of any order except dismissal for default, the court where I don't have determination.
Your lordship is keeping the matters tomorrow.
Tomorrow.
11, my lord. Item number 11, my lord. Restoration. My lord, I have stated in paragraph 8. Paragraph 8, my lord. At paragraph 8, my lord, on that.
There is in view of non-appearance and failure to correct defect.
Defect, my lord. My lord, on that date, my lord.
Tomorrow.
12th, my lord. Kindly see the order, my lord. Kindly see the order. 12. My lord, page 5, my lord. The order.
If it is not simple dismissal for default, I will not touch.
My lord, kindly see the observation, my lord. Kindly see the registered will, my lord. My lord, only for one defect that was not pointed out, my lord.
Can't be restored. This is not an application for restoration.
No, my lord. Kindly see, my lord, the will, my lord. Kindly see the will, my lord. It is registered will, my lord. No defect.
This is an application seeking recall of an order dated March 23, 2026. Full stop. Having regard to the nature of the order dated March 23, 2026, it does not appear that it is an order simply dismissing PLA 62 of 2026 for default or for non-prosecution on the ground of non-appearance of the petitioner, only on the ground of non-appearance of the petitioner. Full stop. Accordingly, comma, let this matter stand released from this list for want of determination. The petitioner shall be at liberty to mention the matter before the appropriate bench having determined.
Without, my lord, any information, my lord, they have
mention it.
Only for one paint, Mr. My lord, you are registered in 14, my lord. 14. My lord,
very well, but it is not simple dismissal for default. It is something else.
Yes. That is correct.
There are observations and all.
That is correct.
With liberty, lordship can save us from this all this.
With folded hands, we are praying with your lordship.
I'll try. Let me first have a talk. Let me have.
We have come before your lordship with folded hands, your lord. Kindly.
Honorable judge is not sitting in a single bench. Again,
that can be taken care of. That is not.
That can be such. Lordship, it will take time.
Your lordship knows the procedure way better than us. Grateful.
Oh, dear.
May it please your lordship, but an existing electric connection standing in the name of petitioner's father
But subsequently, father died, and there are several litigations by the landlord against the. That is a separate aspect. I got civil court's order. I have annexed it. I presently I cannot run the shop, but I am in occupation. My staffs are lying there. They uses the premises. I also use the premises. But before this thing happened, I applied for change of the name from my father who has deceased in my name. They took the money, security deposit, and they changed the name in my name from my father's name. For 3 consecutive months, the bill came September, October, November 2025. 26 bill I received on January. In January, I saw that my bill is not coming in my name, but my father's name. But I made a representation that remains, my lord, unanswered. That is why I am filing this petition. Subsequently, they returned my security deposit, which they accepted. Initially, the CSC returned my father's security deposit because he has changed the name from my father's to mine. This is the position. I simply want the restoration, the connection may be restored in my name. It is lying in name of a dead person. My father is no more. So that in any moment they may come. Well, I'm very much apprehended that landlady, they are in somehow in between. But since their name is not coming, that is why I could not make them party.
Dr. Sara, if the connection was initially in the name of his father, why can't it be transferred in his name later on?
With deepest respect, I humbly submit. Generally, it can't be done, but your lordship kindly appreciate the situation. Your lordship is well aware about that whenever there is a transfer of name, as per regulation 46, regulation 7.2, lordship is well aware about it, that in that case, there are several parameters. If anybody wants to change the name, then on that basis, certain document has to be input. And on that basis, I am showing they have made an declaration. Your lordship knows the online declaration is to be given. This declaration has been given. This meter is initially in the name of Shamatul Kole. Your lordship will find from the writ petition Shamatul Kole. Now, this Shamatul Kole made a declaration under regulation 7.2 specifying that he has got no objection if the meter is transferred in the name of the petitioner. Now, on that stage, we got the letter. We are not aware about it. On that pretext, we have given transfer. We have changed the name. Now, we suddenly came to know that there is a misrepresentation on their part that this declaration cannot be, because at that point of time, the Shamatul Kole died. And your lordship knows that whenever any declaration is given, that is under regulation 7.1, a disclaimer notice has to be given. Your lordship is well aware that if any misrepresentation has been given, then on that basis, the transfer should be. Lordship is well aware. This is the basic disclaimer. Your lordship kindly see. But this is the situation now. Whether it is in the name of Shamatul Kole or Ram Kole, that is not the main Germans to the situation. The main situation is that there is a misrepresentation. It should set a bad example to the society. A person who died, but the declaration has been given in that name, and this is the declaration which has been given. Certainly, I will do. Kindly see. But at that point of time, we got to know that this person died.
My lord, if that is so, my lord, that is, my lord, he has made a mistake. That ought not to have been done. My lord, be that as it may, my lord, my situation is very precarious at the present moment.
No, but if you
My lord, I need something from my learned senior friend sort out, so that we can come out of the situation and get the connection in my name. I need only that much.
But your lordship knows that declaration has been given by the petitioner itself. If there is any misrepresentations, then we are entitled to.
Yes, my lord. Yes.
Why did you
My lord knows he runs a shop. These things are done by agents, by some my lord, some dalals. My lord, that is the difficulty. I cannot because they
neither here nor
whatever
there.
they said.
Before the court is a document.
Yes, yes,
It
yes.
is an illegal document.
Yes, yes, my lord. My lord, I was.
Dead person. How will the court take cognizance of that, and how will the court pardon this at all?
My lord,
Why?
my lord, I can seek pardon from my lord, lordship so that I can come out of it, my lord, because the situation.
If I do it for one, I'll have to do it for all.
My lord, if
That is something which is becoming very dangerous now.
my lord, it amounts to my lord.
Only in respect of electricity connection, it could have been in respect of something more important and more grave than this. What if it was a passport?
My lord, that will has a great effect, my lord. But the situation is that my lord, right now,
How will I
if they
take cognizance of this and then again let you
my
go?
lord, I'll request my learned senior friend also to give me some way out, because our situation is that my shop is stopped because of the my lord, the license I cannot get.
How?
My
But
lord,
then
something.
This writ petition I cannot.
but that has to be withdrawn by him, and he has to apply afresh.
Once this is disclosed to court, and there is no dispute as regards this declaration being issued in the name of a dead person, how will the court go ahead still and direct the authority to give connection to you,
My lord,
ignoring all
এটা
these
আমাকে দিয়েছিল
small
তোকে
illegalities?
এটা ফ্রেশ করে অ্যাপ্লাই করো লাইন কাটবো
my lord, may I do one thing? May I apply afresh for the purpose of so that I can
You always have
name.
but the moment I record this, it becomes dangerous.
My lord, kindly do not record it. My lord, give us some relief so that my lord, I can come up with a phrase application for change of the name of a dead
Let him
person.
withdraw the writ petition subject to my learned friend approval. Thereafter, he can apply afresh. But we are, but kindly don't record it.
কাটবো না লাইন কাটবো
The petitioner alleges
Wait, please, man. I thought the petitioner was not mine. But I don't hear these hearing. My lord, this is an application seeking a limited. Where is my documents? On the physical possession that is due to be taken today, my lord. My lord, there is just
Action.
surface action, my lord.
Why don't you approach the DRT?
I have already approached the DRT and I'll appraise, my lord. I'll just pray for 2 minutes. Once, when this writ petition was filed, my lord, the actual application under section 14 was not in the custody of the petitioner. I should have filed a supplementary affidavit. I do not have it. I have arranged a copy, a certified copy of the same. I beg to present before my lord just to show 2 pages, my lord. I've numbered it.
Why should I go into this if the DRT
I will.
is already in CCN of the
No,
matter?
my lord, I have filed an IA, my lord, but it is not due. It is due today. I have tried my, but I'll just show why this court should interfere and why the precedence that has been laid by various courts is giving me that exemption to come and try my luck in the determination of writ. My lord, at the outset, that document is the application under section 14 that is filed before the for seeking the executive order, my lord.
Who is appearing for the bank?
I have served a notice.
But there is a no order.
I know, but in that case, I may proceed or.
What is your, show me your.
My lord, just a few pages. My lord, first, be pleased to come to page number 74. Not 74 of that. I think it is. Sanction letter to देखिए एक बार. Sanction letter to the नहीं. I'm sorry, my lord. May I please this document? This is the DRT application. It is required. I'll come to that. This is the sanction letter. My lord, be pleased to see the address that has been given as security. My lord, be pleased to come to page number 179. 179. I have a copy of the DM's order, as in the ACJM's order, of this document, my lord. 179. Top middle, my lord.
Yes.
My lord, this is the property details based on which the order has been passed. Let me show the loan agreement, my lord, which property was actually mortgaged. My lord, be pleased to come to page number 15 of the compilation before the ACJM. That is the previous document I've given. Page number 61. This is the property. What happened, the background story, my lord, is that the order which is passed is not against the actual property that was mortgaged.
Yes, so this point is available to you for you.
Yes, I will go before the DRT and invoke the merits of the case. But my lord, I have filed the application.
Even this point can be urged before the DRT. This is not such a point that it cannot be taken.
No, but in lieu of the urgency, my lord, in lieu of the urgency,
it can always be raised over there.
I have raised, my lord. In fact, what I've handed over to my lord.
There is a recent judgment of the Honorable Supreme Court where, relying on a 1952 Supreme Court, the Honorable Supreme Court has urged that if the High Court is relegating a person to the alternative remedy that is available under the statute, it would not pass any interim order.
No, but I don't have the latest judgment. But in the same Supreme Court, lately, last month, has passed a judgment.
That even if you relegate,
no, not relegating.
Pass a stay.
Not relegating, but it is just in order to meet, because I cannot suppress what I have done, my lord.
If you have already approached, your remedy was to approach the same DRT under IA. When was the order of this ACJ and SDJM passed?
This was passed around, I'll just confirm the order. This was passed on 13th of May, but it was only communicated to me around 18th of June, my lord.
Very well. So you had still time.
No.
You are almost on 16th of July.
No, I think it was 3rd July. 3rd July, they have
Sir, your
replied to one.
Your writ petition is of 13th of June. Your writ petition is of 13th of June.
Yes.
On the same day, why could you not have approached the DRT? Your writ
Because
petition has been
there was
26.
my lord. What happened, my lord? I have received. My lord is absolutely correct that they have proceeded. What happens, my lord? I was not.
The ACJM's order is impugned in the writ petition. It is 13th of May 2026. You have filed it on 18th of June 2026. On the same date, you could have approached the DRT and pressed it.
I couldn't have, my lord, because I did not have the requisite documents, and I'll tell my lord why. My lord, be pleased to come to.
You have before the High Court, you could have approached the DRT with them. There is no such requirement that you can approach the High Court with 5 documents and DRT would require 6 documents for you to
my lord,
approach.
no, my
That is
lord.
not the law.
But before the High Court, I can only challenge the ACJM's order, the executive order. But in DRT, I can get into the merits, so which is why my actual remedy lie with DRT. I'm not objecting to that.
That doesn't mean that you will obviate the statutory remedy and come before the High Court. You have to show that your case is so extraordinary that the High Court should intervene despite the alternative remedy.
My lord, give me just 1 minute time. My lord, be pleased to.
Minutes, I have not been satisfied.
No, I understand. My lord, be pleased to come to. My lord, be pleased to come to page number. Now, section 17 remedy. I could have only invoked once 13.4 is invoked.
13.4, section 14 is a step under 13.4.
My lord, 13.4 was not adhered to. That is my proposition. Why?
Therefore,
why, my lord?
Therefore, it is an action under 13.4 which according to you is irregular and therefore the DRT remedy. Clear? Every action under section 13.4,
yes,
under section 14 is a step under section 13.4. Every step under section 13.4 is saleable under section 17 before the DRT. So therefore, every action under section 14 is assailable before the DRT under section.
I agree with my lord. I agree with my lord on that point. What I'm trying to impress upon my lord at this point in time is the irregularities, and I'm seeking a limited stay up till my matter is heard before the DRT.
Not at all. This is exactly what the Supreme Court has deprecated, relying on 1952 Supreme Court. It's a recent judgment.
I know, but I think it was. I have a copy of the judgment my lord is referring to. I have it handy. I think it's Mr. No, return one. Judgment is
February 2020.
February 2020. Agree. I have the judgment, but even that is exempted because of 13.4 procedure. My lord, be pleased to check one document, the sanction. So
your challenge, Mr.
What happens, my lord? What is the predicate? What is the predicate?
13.4 only. It is not something which is beyond 13.4. It is 13.4 only. If you had challenged something else, an action of the bank in doing something else which is not a section 13.4 measure, your challenge is that this section 13.4 measure or the section 14 measure is not in accordance with law. That is within the DRT's domain. It is not something else than surfacey action. It is surfacey action. Whether it is the action has been taken in accordance with the surfacey procedures or it has been taken in violation of the surfacey procedures will be a question before the DRT to answer, not before the High Court.
Absolutely, my lord. But there is another phase of it. This is an executive order passed by a ACJ. I understand that this cannot be challenged before any other court, save for writ court, or a DRT can reconsider the order passed. But the actual remedy, because under section 14, in my view, there have been, even Satyavati Tandon also speaks on the same line, that the actual remedy lie whether there is any perversity in the order passed. That lie with the writ court. Or else I could have preferred a review.
It is not the actual remedy that lies before the writ court. What is said is that notwithstanding the alternative remedy, the writ court...
Yes, so that is what I was trying to impress upon my lord. If my lord is not inclined...
Actual remedy is always there. Writ court
may
not relegate you to the actual remedy if the writ court feels that this is a case which can compel the court or persuade the court rather to exercise its discretion in entertaining the writ petition despite the alternative remedy being available.
Right. To that point, my lord, my argument is very limited on 2 points, my lord. Number one, the order that actually orders to take possession of a physical possession of a property is not the property actually mortgaged.
That can be taken care of by the DRT.
Yeah, but then this is an extraordinary. I understand what my lord impresses upon. But in that case, can I ask for, may I pray for a limited direction by this court so that the DRT takes this matter on a urgent basis?
I can direct that.
Much obliged, my lord. That will be serving my purpose.
This
Thank you. 19, my lord, I am appearing on behalf of the petitioner. My lord.
I appear on behalf of CSC.
This is the affidavit of service. My lord, facts of the case is that the petitioner is the owner of a land. The respondent number 7 is the owner of an adjacent plot of land. My lord, earlier, the private respondent number 7 was trying to take electric connection and water connection over the property of the petitioner. The petitioner filed a suit for declaration and also filed an application under Order 39, Rule 1 and 2. And the said application was allowed and passed an order of interim injunction, ad interim injunction. I am inviting your lordship, kindly come to page 71. Got it, my lord?
These are all has been dealt with deepest of respect, my lord. But this reputation is not maintained.
Another thing, my lord.
My lord, is kindly,
Respondent number 8.
kindly,
Whose cable connection has been given? He's not before your lordship.
right,
My lord, let me submit, madam.
come to page 87, my lord. There was a direct.
My lord,
Page 71.
page 71, my lord, relevant portion, ordering portion, my lord, page 72. That the temporary identity, got in, my lord? 72. That the temporary identity injunction as prayed for is hereby allowed ex parte in terms of the observation as above. Both the parties to the suit are hereby directed to maintain status quo in respect of the nature, character, and position of the A schedule property. A schedule means, my lord, the petitioner's property. As on date till the next date, plaintiff is directed to comply with the provision such and such, my lord. Thereafter, my lord, the said order of injunction was communicated to the CSC authority, Distribution Company Limited, my lord, CSC authority. And in spite of that specific direction, my lord, the private respondent took electric connection over the property of the petitioner. Consequently, my lord, the petitioner filed one writ petition. I am inviting your lordship, kindly come to the order of the said writ petition. Annexure P8, page 82.
Yes.
Page 82. One relevant portion, ordering portion 87.
Yes.
In such view of the second paragraph, in such view of the matter, particularly since no application for contempt of the injunction order has yet been filed before the trial court, which is taking up the civil suit, it would be premature to
the magistrate.
Yes, my lord. Accordingly, my lord, the petitioner approached before the district magistrate. District magistrate, my lord, heard the matter after issuing notice to all the parties. My lord, the order, page 93. Annexure P10,
Page 93.
page 93.
Yes.
Order dated 3rd of May 2023. Taken up the matter for hearing today. Petitioners along with lawyer filed Hajira, private respondent filed Hajira, the district engineer CESC Limited filed Hajira, the BL and LRO Sakrail filed Hajira, the inspector in charge Sakrail PS filed Hajira, heard the petitioners who demanded for shifting the underground electric connection from their property. Private respondent claims that the electric connection is effected through their property. On the basis of such submission, the district engineer CSC Limited is hereby directed to cause a joint field inspection with BL and LRO Sakrail with prior intimation to the petitioners and private respondent for remaining present.
Yes, what happened then?
My lord, thereafter, in pursuant to the said order, my lord, the one joint inspection was held.
Yes.
But my lord, said joint inspection, if your lordship kindly come to page
That is
joint-
at page 101.
joint inspection was held, but no fruitful result came out. Consequently, another joint inspection was held. My lord, I am inviting your lordship, kindly come to page, my lord, page 99. My lord, second time the matter was placed before the DM and DM passed order, my lord.
So this
Page
time
na-
three
na-
people were directed,
page-
BDO, BLLRO and district engineer.
Yes, my lord, page 99.
I've read it.
Yes, my lord. Thereafter, in the meantime, one Purnima Sepai filed one writ petition. My lord, that joint inspection was held, but no copy of the inspection report was handed over to the petitioner in spite of, my lord, in spite of specific.
What has happened now?
My lord, thereafter, my lord, one, let, my lord, thereafter, one Purnima Sepai filed one writ petition. And the said writ petition, during the pendency of the said writ petition, the block land and land reforms officer filed a report, which is annexure P14, page 100. Got it, my lord? Page 100.
Yes, page 100.
In regard to the above noted subject matter and reference, it is to state that one joint field inspection was conducted on 28th of May 2025.
The letter of communication, I mean, letter
My
communicating.
next, very next page, my lord, with the said letter, my lord, inspection report was, my lord, if your lordship kindly come to page 101.
Yes.
The following matter is transferred from the inquiry report of the RI. The undersigned underground electric cable line was made visible to the inquiry officer by digging it out by concerned CSC personnel. Point number 2, one common passage which is connecting the GP road, Gampanchayat road, my lord, and the said Ula Sasto Kendro, Susasto Kendro is situated on LR plot number 1021. That is the means, my lord, 1021 is the land of the private respondent with a measurement of 5 feet. The disputed electric line is running just under the common passage, which means the electric line of CSC is running through LR plot number 1021. Petitioner of this WPA number such and such, namely Basanti Sardar.
Read it. Thereafter.
Thereafter, my lord, my humble submission is that, my lord, in the year of 2012, the petitioner made an application under RTI Act. My lord, in reply to that RTI Act, my lord, one inspection report was filed. If your lordship kindly come to that report. Page, my lord, 106.
Yes.
Point number 1, DAG number 1021. Point number 2, by the Secretary, Women's Development Association. And point number 3 to 6, you are requested to contact the Secretary, Women Development Association, Mr. Srimati Purnima Sepai, and the Pradhan Nolpur Gram Panchayat for further information in this regard. My lord, if your lordship kindly come to next page, my lord, page number 107. Page number 107. My lord, that inspection was done by the government official, and also the report which has been annexed during the in connection with the earlier writ petition, my lord, both measurement totally different. If your lordship kindly come to page.
Whose report is this? Page 107. This is a site plan.
107.
It's a site plan.
And this is the report of.
No, my lord. This was supplied in reply to the RTI Act and
What
supplied.
was the question in answer to which this was supplied?
My lord, yes, my lord.
What was the question in answer to which it was supplied?
Page number 105. Plot number.
So you did not ask for inspection report. You have asked for something else. That is why it
My lord,
has been supplied.
Another thing is that, my lord, the petitioner.
Is relevant with the inspection?
Inspection report, my lord, both the sketch map, both the measurement are totally different. Not only that, my lord.
How is this relevant, sir? Inspection has been done upon surveying the land on actual basis.
My humble submission is that, my lord, the surveyor, my lord, has not taken measurement properly. My lord, another thing is that the petitioner filed one title suit which is still pending, and in connection with the title suit, one commission was held.
You take this point before the DM. Why are you coming here in the writ petition? The proceedings before the district magistrate are pending. You take this point before the DM.
My lord, I am challenging this report because of that TM already disposed of the matter.
No,
Where
is the order disposing of?
there is no
No.
order, my lord, DM has not disposed of. That is my instruction. my lord.
No, my lord, DM
Show me the order.
page 99.
Page 99.
The block development of in 7 days.
Page 99 is
My lord, kindly see page 99.
yes.
The matter is thus disposed of.
This is in respect. This
Let
is in
a copy of
respect
the order
this
be sent.
order. Well, kindly see just above that on the basis of such submission, the block development officer Sakrai block is directed to cause a joint field inspection along with CSC and BLRO, Sakrai block and the district engineer CSC Limited, Howrah, with prior intimation to the petitioner and the private respondent for remaining present on the
And
date
submit report. So he is called for report.
My lord, kindly see the matter is thus disposed of.
Maybe he has written that, but what will he do with the report? If the report is submitted after disposal, what will he do?
If your lordship kindly direct me and also direct the TM to.
Consider this
Well,
report.
that
Yes, my lord.
is already there. Kindly, well, in the earlier order,
Only because he has written disposed of, he is also.
well, my instruction is the order has not yet been passed.
My lord, the matter is the disposed of.
Entitled to take exception to this report. Go and take exception to the report.
My lord, only one thing, my lord,
Yeah, that
previously
is
a
always-
petition, earlier to that, my lord, a writ petition has been filed by respondent number 6, my lord, Women's Development, and several orders has been passed by my lord Justice Kapoor, my lord. That order is not before your lordship. In that writ petition, my lord, his lordship have passed several orders directing the district magistrate to submit a report and for joint inspection, and also directed the BLLRO to inspect the spot in question. That report is not before your lordship, my lord.
I am not deciding anything on the basis of the report. I will just say that the report which he is now showing, he will be entitled to take exception. You want
Yes,
to take exception, you also take exception before the district magistrate.
And the district magistrate is also directed, my lord.
My lord, I shall produce all the orders passed by this honorable court, my lord, in the earlier writ
But
petition.
what is the purpose? I am not disposing of this
Yes.
on merits. The matter is pending before the district magistrate. District magistrate will take the decision in accordance with law. He will deal with the report. If a report is being relied on, he must get an opportunity to contradict that report if
Yes.
he wants to. Let him
Well, that
contradict
is-
and file his report. If you want to take exception, you also take exception to that.
Yes.
It can't be on the basis of the report only. People who are affected by the report must have a copy of that to say that the report I am not agreeing with or I am agreeing with. Whatever. You also have an opportunity to do that.
My lord, also direct the
Of
district
course.
magistrate to heard the
My
matter.
lord, my lord.
Well, it is already there.
No, my lord, the matter is thus disposed of.
He's right in saying so. If he writes disposed of, then
Yes, my lord.
how will people know that it is disposal and
Disposed
still
of
it is
means-
pending?
সামনের সপ্তাহে একটু রাখুন, আমি-
If it is disposed of, it can't be pending.
That is true, my lord.
But-
In that two word, I cannot say anything.
Direct the district magistrate and also.
My lord,
You want time?
my lord, yes, my lord, because my lord, I have to place the orders passed by Justice Kapoor, my lord.
What order?
Order
Yeah,
passed
let
করেনি
him
Justice
play.
না
Kapoor.
না
Justice
go to the
Kapoor
their team. না না
Justice Kapoor order দেয়নি।
না না সে তো এই মর্মে কিছু
And I will
order
also
to
inquire
discuss
whether
the
it has
judge,
been,
sir.
any order has been
And-
passed after that.
This writ petition
আমি অ্যাডভোকেট অন রেকর্ড, অ্যাডভোকেট অন রেকর্ড।
Yes, yes.
My lord, not today, my lord.
Not today. Not today. Next.
Lordship, the
Item number 21, I am appearing.
Lordship,
the
I am
respondent
praying
number
for.
5. My lord, I am appearing for respondent number 5. My lord, my client has just received the notice 1 hour back. My lord, I don't.
1 hour back they have received
instructions. My
Lordship, this is
only thing, my lord, there was a direction.
Lordship, kindly see the direction passed to your.
You have not received form. They are not
Yes,
accepting.
yes. Lordship,
we
kindly
have-
see the form has been received. And Lordship, the letter they have issued, that is on the same day. This is the acknowledgement they have received the form. And Lordship, kindly see the letter. On the same day they have. And this is my service to the private respondent, Lordship.
So they have asked for valid documents. Show whatever is there.
Yes, Lordship, kindly see all the documents we have submitted. Lordship, these documents I have annexed in this writ petition also. Kindly come page.
My lord, it was submitted.
So very well. They have asked for you. You submit once more. What is your problem? You can't submit in response to your letter. Submit it.
Also, I will submit page 71.
Fight every time. Submit. Submit the documents. Your purpose will be served. You will get electricity connection. Yes. When will he come?
My lord, kindly keep the matter on Monday.
Let
Only
his,
1 day's accommodation.
He has received copy only today. You have made him a party.
Yes.
Let him come.
He is the Lordship, the owner of the building. Lordship,
You have made him a party. I can't just brush him aside.
yes.
He's a
So
party.
if she has an objection, Lordship, the landlady has an objection, then Lordship, kindly fix the matter. If she has no objection, then
That he is unable. He is seeking time.
My lord, I need to go through the petition.
Unnecessarily, why are you
same
putting it in
petition, Lordship, my landed friend is appeared. Order passed in respect of the another tenant. Same, Lordship.
Yes.
My lord, in that case, then kindly pass the same order with a liberty that there should not the
Yes, yes.
petitioner should
Page
not issue any
111,
right
Lordship, the same
over
order.
the-
That I will do.
over
My
the-
lord, according to your lordship's direction, my lord, yesterday they went and submitted some document, and yesterday only we have sent this letter, my lord. In terms of this letter, if they submit
Satisfy
this,
that you are in settled possession. If he satisfies that he's in settled.
Yes, I am the tenant since
and
last
in
30 years.
and in
Your documents.
Yes.
Okay.
Lordship, kindly come 111 of my writ petition.
my lord, I don't know.
Submit it to them.
My lord, in this matter, I am for the state.
I don't know what
There is a
document they have
report, my lord.
submitted.
I am for the state respondent report. There is a report.
It has appeared.
But I don't
They
know what
lordship,
documents they have submitted
They
yesterday.
will submit the documents, Mr. Mukherjee. I am saying you will submit
Oh,
the
Raja.
documents
Lordship.
in support of your occupancy, and that you are in settled possession. If they find that the documents are in order, within 4 weeks from compliance with all necessary formalities, they will.
Lordship, kindly consider page 111.
That is for them to consider. Everything I cannot consider on the basis of.
They have to let them submit this document, and subsequently, according to
In course
compliance.
of, I have instructed in course of today to submit all these documents.
I don't know.
State is not
No.
required.
No, Lordship,
No
this.
concern, but there is a report for it, so I am submitting.
Yes,
My lord,
yes, I am
kindly record
taking
my
it.
submission. My lord, kindly,
হ্যাঁ হ্যাঁ এই তো আপনার এই
my
অর্ডারটা
lord, kindly record
Yes,
my.
he will not have any equity. I will record that.
Time for respondent WBS recent.
Taken in. None appears for the petitioner, but today there is again no adverse order. ছেড়ে দিন আজকে. That will be a problem.
Yes.
Next. Out. Not today. No adverse order আছে না? Dismiss করা যাবে না. Next.
The division
Over.
crime formal respondent.
Not today.
And tomorrow I have to difficulty meeting on Monday.
Tomorrow, if you are not there, I will make it on Monday. Not a problem. They are not there in their absence.
No, only Monday.
But I'll have to pass an order. Let it be unnecessarily by.
Try the license.
Not today. Not today. Not today. এক পক্ষ থাকলে আর ফাইল দেবেন না, এমনি কল করে যান, লাভ নেই তো। তো নো অ্যাডভান্স অর্ডার আছে না, এক পক্ষ থাকলে আর ফাইল দেবেন না।
The chariot has already rolled, I think. The chariot has already rolled.
কল করুন।
হবে না হলে হবে না।
এসে গেছে।
কি হবে? 75 appear for the petitioner lordship.
Not I beg to appear for the West Bengal Electricity Regulatory Commission, the Ombudsman.
Private party is
Private party is not appearing, Lord.
You are there. Let us.
I'm here.
You are ready.
But private party is present because they are the consumer.
Very well, but if he can defend his order and your writ is dismissed, what is the problem?
As your lordship is.
You have served a copy on the private party.
Yes.
In terms of the.
It was served, yes. I served today also, my lord. I had a talk with him. And my lord, on WhatsApp, enter petition has been sent.
Then I should wait because adverse order is this resolution for no adverse order is there. What do you think here? His writ will succeed or fail?
Pardon, Lordships?
His writ will succeed or fail?
Certainly it will fail.
Then let us have it. Then there is no adverse order against your opposite party.
I do not know, my lord, but I still I am in hesitation, my lord, to understand as to what role the ombudsman will play, because it is a file.
Ombudsman will support his order.
My lord, if they oppose, that means it is prefixed. They have fixed up their mind. They will fight for the consumer. Then how the complainant will get the my lord relief?
I shall fight
That's
for
the
the
issue.
order. It may be sometimes it is in favor of the code also.
Whole issue is, my lord, when we are litigants before ombudsman, is the authority.
Very well. You what is the order impugned?
Not delayed in giving connection, my lord. Compensation has been awarded.
We take it that the other matters are released.
No, why? You can leave I will not dismiss any matter for default or pass any ex parte order. That's not a problem.
And my lord, I must be candid, my lord, today also my learned petitioner, my lord, Mr. Samanto he told me that I'll not come today. Only for today. Then I requested him, you ask somebody to appear on your behalf. But
If not today, tomorrow we'll take it up again.
But only not today will not justify our efforts.
Very well. লিখে দিন। লিখে নিন সমর বাবু। Although the petitioner and the ombudsman are represented, none appears for the private respondent, full stop. List this matter. When should I keep it? Tomorrow? Or tomorrow he will appear?
He has told me that today you will not come.
List this matter on Monday.
Today.
Tuesday.
List this matter on July 21. 2026.
Let it be on Wednesday. 21st is. I do not know what happened.
July 22, 2026.
20th.
The petitioner shall inform the learned advocate appearing for the private respondent in the meantime.
My lord, he has given me, my lord, this task may not be given, this order may not be given, but I will inform. I'll inform.
There.
This line may not be, my lord, given because.
দেখি আমাকে দিন দিন ফাইলটা পাঠ করুন next not today করে যান কল করে যান আর তাকাতে হবে না 79 কি 82 of the act
70, my lord, 78, 79, 80, 81, 82.
not today
These matters, my lord, maybe, I have instruction, this is very old matter, but I understand in the meantime, my some instruction is that most of the matters have become infructuous. Because compensation might be settled or something has been happened because last 10 years. It's a matter of 15.
Become infructuous. I will dismiss it accordingly.
Maybe. So, my lord, I'm trying to, today I have got an information that already, my lord, the compensation has been paid by the concerned department, Sahib Kundu. But I am yet to get that confirmation.
Very
If it
well,
is
I'm
done,
making it not today. You come tomorrow, tell me. I will.
not tomorrow, my lord, in 2 days, my lord, I may not get confirmation. At least 1 week, because to pursue what is the information.
78 to 82 লিখে নিন
Well, let it be de-tagged also. There is no, these are not similar matters. The facts are similar.
Why has this been tagged?
I do not know. Lord.
দেখি ফাইলটা দিন
সেদিনই করে নেওয়া যাবে ডেট দিয়ে দিন হচ্ছে কি বলবো বলে দেবো কি করে না জেনে না একটু না জেনে অ্যামাউন্ট করে বেশি আছে আমার সমস্যা জেনে বলা উচিত মিলট দিস ম্যাটার্স আই উইল টেক ইনস্ট্রাকশন whether this have already become infructuous or not.
There is a direction of tagging. Since I propose to take up and disclose all these matters together, irrespective of whether this has
That time it was.
Or not, that was
But beloved, if my learned senior friends wants to proceed with the matter, I have to deal each case separately, my lord. The facts are completely different.
Very well, not a problem.
That is
unnecessarily there will be an order
all right.
again, de-tagging. লিখে নিন as prayed for by Mr. Naik, learned advocate appearing for the these matters after a week.
Yes. But in this matter, I am for the appellate authority. Matter challenges the CSC against the order of the appellate authority under section 127.
Petitioner is not there.
I do not know, Milord, whether he is they are appearing or not. Who is.
Not today, not today. Chalo, next.
84 Lordship, 84 and 85. Same. Maybe other. But in road matter, Milord, already.
ওই 79 to 82 এর যে অর্ডারটা হলো 84 85 এ একই জিনিস কপি করে দিন।
If already settled, Milord, it is of no use because that time the seriousness was there, awarded compensation. So, Milord.
Next.
But 86, Milord, I beg to appear for the Milord WBRC, Lordship, electricity regulation.
What is there?
Your Lordship, in item number 86, Mr. Tonoy Chakraborty is appearing on behalf of the petitioner, Your Lordship. I was only instructed to pray for Your Lordship a day's adjournment if Your Lordship misplaces.
1 day.
1 day's adjournment.
But one more Milord, order I need, Milord. I do not have any copy in my records in my office, Milord. If my learned friend provide me a copy of this application, Milord.
Yes.
We had served copies so far as I can
It's a change
recall, Your
deed,
Lordship.
Milord. It's a 2022 matter.
Yes, it's a 2022 matter.
Serve a copy. দেখি একটা অর্ডার রেকর্ড করে নিন 86 এ
Great, Lordship.
As the Lordship directs.
I am for the petitioner. My land friend, my instruction is that to withdraw the read petition, new connection in 2020, my lord, quotation money deposited. My prayer is that, my lord, to withdraw the read petition with liberty, my lord, to approach the authority to, my lord, the refund my security deposit, security, my quotation money, my lord. From 2020, my lord, quotation money was deposited till date connection. So, my lord, I withdraw the read petition with liberty, my lord, to.
Milord, whether that liberty could be given or not, this needs to be
if you have
tested.
slept on his application for so long without granting him electricity connection, he will not grant electricity connection. Take quotation money. Why will you not
Report
take
was there a direction for filing report. But report is ready. May I file this report? And may I place the report also?
I'm withdraw the read petition because, my lord, they have
Milord, if Milord
simply
simply
want to
withdrawal,
withdraw very well, but if you want
if he wants to withdraw simplicity, Milord, no issue.
liberty to file appeals on the self.
No, not liberty, requirement only to refund my security, my
That I
quotation
know
money.
whether
Quotation money,
you refunded or not.
55,000, my lord, 55,659, my lord. I have deposited, my lord, in the year 2020 without any interest, my lord. Only
Well,
for
on the self same cause of action, he is always at liberty. My lord, he can file a case. But if my lord says that particular term, there is liberty to file on this for withdrawal, then my lord, it gives lot of right to him.
Mr. Mondal, it's not that easy. The connection was refused because an amount of rupees 5 lakh and odd was due from your father.
Yes, my lord. That part, my lord, also division bench also passed the order. Several order was passed, my lord. That was.
So if that is the case, then in
My lord, I have applied for fresh connection. If they, my lord, before quotation money, he has stated it.
on merits or you withdraw, you can't take back the security. If there was no money lying
So,
with
my
them,
lord,
then
I
in that case,
simply, my lord, withdraw, my lord.
bring a letter. Bring a letter from his client.
Next.
Taken in. Report is
the regulatory commission.
nobody is there. Not today. Next.
92, my lord, I am for the respondents. I do not know his appearance.
Not today.
I am for the ombudsman.
Not today. देखिए 96 টা একবার না ঠিক আছে চলো দেখুন
But I am for the regulatory commission.
101 lordship I appear for.
Yes, not today. Not today. চলুন চলুন
Lord, I appear for the. I am for the opposite party. Will respond. But I for the petitioner lordship.
আস্তে 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 আস্তে
নামটা পড়বে Well, I am told that item number 98, if my lord may kindly see, list to দেখি, list to দেখি।
98 what has happened?
98, my lord, I think my lord has appeared in this matter.
98 দেখি 98 টা দিন তো রিলিজ করে দিন
এটা তো ছিল। Sure.
There will be several matter of this type.
Yes, my lord, it is there.
Release করে দাও।
My lord has appeared as my senior in this. এইটা একটু দেখিয়ে দেব।
Not required, it will be there in the records. 1998 টা দিন। Yes. লিখে নিন আমার
এই নামটা দিয়ে দেন না। ওই অর্ডারটা দিয়ে দাও। অর্ডারটা যেটা দিলাম নাম দিয়ে দিই অর্ডারটা।
আস্তে আস্তে
At least the list is exhausted today.
Yes.
Welcome.
Thank you.